So when we talk about the ombudsman process, we say a consumer has a grievance. They bring that grievance to the ombudsman. Before doing so, they have to go through an 8-week waiting period where they have a direct negotiation with the trader. After that 8-week waiting period, they can continue through to the ombudsman process, which is an exclusively written process. All evidence is written. There are no depositions, no testimony. The ombudsman evaluates, makes a judgment, and makes the award all in one process. It's important to understand that this is an unbalanced process. So on one hand, this is entirely industry finance. Consumers don't pay for this process. And on the other hand, consumers are not bound by this process. So in the event that the consumer loses, they can still take the case, the dispute, to court or to another ADR provider. Whereas it's not the same with the trader. The trader is typically bound up to a certain euro threshold, which includes the vast majority of cases. So basically, this is kind of an important kind of lack of equivalence here between the two sides. And in order for this process to kind of be credible with consumers, there's this oversight advisory board, which is kind of composed of both members of industry and members of consumer protection organizations, as well as experts from academia, government, science, other places. So basically, you have an industry finance system where the industry participants are bound, but the consumers are not, and you keep it considered kind of fair through the use of this advisory board and this kind of organizational independence. The ombudsman is actually physically separate from the association in order to make it look as kind of fair as possible. So we can move on to the next slide here. Key challenge here is how do we get from the ombudsman model that we think is kind of widely accepted in Europe, how do we get from that base model to something that's optimized for ODR? So on the left side, we have kind of three characteristics that you'd want to see from an ODR process. Widespread participation in terms of e-vendors. Right now, we're only talking about that this ADR scheme of ombudsman, industry ombudsman, is really limited to large, regulated, organized industries, which is obviously not the same thing as what we think of when we think of as e-vendors, where you have small transaction sizes and lack of organization of those e-vendors. And the second question is, how are we going to scale this process? The current ombudsman model it takes months, not days. There are less than 10,000 cases handled per year. When we talk about the future ODR world, we're thinking about a faster process handling up to millions of disputes. So we all use the Colin Rule statistic of 60 million disputes a year at eBay. So how are we going to get from here to there? While at the same time maintaining trust. Trust is the key characteristic here of why people are willing to opt into these systems. Finally, how are we going to have reliable outcomes? Right now, consumers know if they go through these processes, they know that the trader will most likely be bound by the outcome. So that there's a certain reliability built into the system. So a big problem is how are we going to get vendors and consumers to actually opt into these systems to kind of either be bound or at least be able to rely on the likely stickiness of an outcome that comes through one of these processes. So those are kind of the key challenges. And our final kind of finding slide, the next slide, slide 13, will kind of show you just kind of some things that were really influential in our thinking in developing the recommendation. So basically, this is a kind of information point here. For one thing, why are vendors joining? This participation is a really big challenge for us. Why are vendors joining ombudsman systems right now in the bigger industries? We're hearing basically it's reputation and cost. Court costs a lot of money, in particular in Europe, where you have a loser pays model, where you have a loser pays model, plus you have, in particular in places like Germany and in others, you have legal insurance. Going to court is a pretty attractive option for many consumers. So these vendors are basically seeing it as a cost savings aspect here. But then more importantly, perhaps, there's a reputational aspect. These vendors are advertising to their customers, in the event that there's a dispute, you can trust us because we're part of this ombudsman process. So it's a way to retain and build your customer base. Secondly, stakeholders from both sides are saying that they want market solutions. They don't want a kind of top-down EU, highly regulated solution here, and the national governments are feeling like they have their own court systems that they have to focus on, so they're not looking for another kind of regulatory burden whereby they're really closely monitoring these ADR providers. So given those two key findings, this last one is an important and surprising one. Strict enforcement, by which we mean kind of a binding rule in the kind of spirit of the New York Convention or something like that, that ranks very low among both ADR providers and the consumer protection organizations. Last and second to last in those two surveys that we ran. So what's the alternative to kind of strict enforcement? Well, we're seeing in Germany that online trust marks are quite prevalent, and in Sweden they use blacklists for companies that don't comply with the ADR schemes that are in place. So there are kind of reputational feedback mechanisms that are in place in different European countries. So on the bottom here, we kind of show an example of how a future might look. So the biggest trust mark in Europe for e-vendors is called Trusted Shops. Their biggest market is in Germany. So what they're now doing is saying we're going to require, as a condition of getting our trust mark, our vendors will agree to participate in something called Der Online Schlichter. Der Online Schlichter is an online mediation tool. It's Germany's only pure play ODR provider. It's the only exclusively online ADR process that exists. So the interesting thing here is that this trust mark is kind of playing the role of the industry association. Previously, the vendors are participating because they're a member of the association, and the association requires them to be, to be involved in the ombudsman process on request of the consumer. Right now, under this model, the trust mark is kind of requiring that same participation as if it were an association. So that's the kind of interesting kind of shift here, going from our large regulated organized industries into an e-vendor less organized kind of setting. And importantly, Trusted Shops is an international organization that has a representation in many different European countries, so it is able to kind of bridge the gaps between different countries. So those are that's kind of information that's really informed our discussion here, and we'll move on with Eugene, who's in Rochester, New York right now. He'll give an outline of the actual recommendation.
Can I ask a question first? Can you
Sure.
go back to that other screen for a sec? The 13? So under, the trust shops, is that equivalent to like a Better Business Bureau?
Yeah, that's very similar. It's a Better Business Bureau, but Trusted Shops' clients or customers, depending on how you think about it, they are all online retailers.
Okay, so has any consideration been given to groups such as Google? I think Google has something where they offer their own trademark now, that it's a Google Trusted Store, something to that effect. I can't remember the name. But that is a very, to have something like a Google that is non-business or a non-association, a trusted shop. Is Trusted Shop going to be the market leader in the future, or is it going to be, or are e-companies going to be looking more to like getting a Google trust mark? Did you get any sense from the interviews?
Yeah, I mean, it's a good question. I think, certainly Google has a powerful market position here. We were careful to kind of understand the private market here, that, especially when it comes to reputation feedback, that it could kind of play out in a variety of different ways. So these trust marks are private companies. So it is important to note that they also are a kind of private player here. I think one thing that was relevant to us, which kind of comes up in our discussion a little later, is that the EU right now is considering trust mark regulation, where they define minimum standards for what an acceptable trust mark is. I mean, the big problem is it's whether or not you can trust the trust mark. So, you know, if the trust mark is just giving away its seal of approval for, you know, for a certain fee, that's not really to be relied upon by the consumers. So the EU is kind of saying they expect that trust marks will be a more important part of the online economy in the future. So they're trying to start regulating and setting minimum standards for these trust marks. In the event that Google were to participate in this and you know, kind of set minimum standards, or not set minimum standards, but you know, indicate reliable customers, you know, that may either spawn a third-party ODR system. It may fit in with the European system, or, you know, it could, I suppose, create a much smaller need for a ODR system. So we don't really know kind of how that would impact. I mean, I think our recommendations are modular enough that they would work with whoever is providing the kind of the trust mark value here.
You know, I will say, just in line with what I'm going to mute for a second, Daniel, because I know I've got a lot of background. I did talk to Google, and I talked to their trusted stores program, and I think they are interested in providing trust marks, but they're looking only to high trust merchants. So I think the big problem is going to be getting to that lower tier of non-known merchants. I think a lot of people, it's easy to run a trusted shop or trust mark program for really well-reputed merchants, but the challenge is going to be dealing with it. So when you see somebody like Google come in, yeah, they have a lot of market power, but the question is, do they have the mind share from an independent perspective? So it's it's an interesting question as to who should own these systems, and is there going to be a roll-up, and is there going to be one definitive system at the end?
Yeah, I mean, I think, you know, I'm handing over to Eugene here for the recommendations, but I think, you know, the key connection for us is one of the hallmarks, or one of the characteristics of being a reliable e-vendor is a willingness to participate in some kind of ODR scheme. So, you know, we would imagine that one of the metrics for becoming a reliable or a trusted shop or whatever it is could be participation in some kind of dispute resolution process. And we think that this ombudsman model scaled for e-commerce is something that would fit well. So I think we can move on to the recommendations here with Eugene.
Hi, everyone. Can you guys hear me? See me?
Yes, yes.
Great, excellent. So thanks for joining us, and thank you, Daniel and Layla, for taking us through the first two parts of the presentation. I'm going to talk about recommendations and start out with highlighting once again the top three takeaways that Layla mentioned earlier in the presentation. And the top three recommendations that we came up with are to build Europe's e-commerce ODR infrastructure based on the Ombudsman model. It's to use technology to scale the Ombudsman model to be able to handle high volume, low value disputes, and to create a data sharing platform that would collect important data and distribute it to the key players in a way that would show them the costs and benefits of this program in a way that would hopefully induce them to participate in the system and promote consumer trust. So on that note, I'll talk about the first recommendation, and that's building on the Ombudsman model. So the Ombudsman model basically does three things for our system. One of the key challenges for Europe right now is that ODR, for many people, is undefined, and that was sort of one of the key takeaways of our survey. Many people just don't know what ODR is. Now, if you associate ODR with the Ombudsman model, that solves much of that problem because the Ombudsman model is well known across Europe. It's widely recognized. So people, both consumers and traders, have used it before, and they know the name. Moreover, the Ombudsman model is adaptable. So different parts of it, for example, the complaint mechanism, the negotiation mechanism, and so forth, they can be moved around and modulated to handle different kinds of disputes that arise across different geographies and different sectors of the economy. Moreover, as our survey found, the two key values that stakeholders care about in an ODR system are availability and reliability, and the Ombudsman model delivers on both of those. It's available because it's prevalent throughout the EU. Almost every country has an ombudsman system that's pretty well known and well regarded, and it's reliable because it's optimized to ensure neutrality. Because the key to the ombudsman is it's one step removed from the industry. It's got a more neutral bent to it than just a plain industry association would. Finally, European stakeholders would like to see the system built upon the existing infrastructure and not represent a significant change from the current status quo. So for one thing, the current EU proposal envisages this platform as a clearinghouse that would be a directorate for ADR providers, and the ombudsman model scaled with technology can work greatly with that, can be very well integrated with that platform, and moreover, it does not represent any sort of additional burden or additional cost on top of that structure. So as far as scaling the model, that's the next slide. So on the left, we have the ombudsman model as it currently is, a somewhat simplified version of what Daniel went through earlier. We have consumers filing a complaint against the trader, they negotiate for about 8 weeks, then it goes to the ombudsman who receives all this evidence via writing, makes a decision, and then lets the parties know. Of course, the consumer can always opt out of the decision. The way we see it is we'll insert a few technology-based steps in the process, and hopefully those steps would make the process faster. So the first step would be facilitating negotiation, actually direct negotiation. This would be negotiation that would be sped up by a technology provider. After that, if that has failed to induce a settlement, the parties will move into the ombudsman process, and at the beginning of that process, when they submit their evidence, technology will produce a predictive evaluation of the outcome, which in itself might help the parties settle. And finally, once the ombudsman makes a decision, if that's necessary, that would go into the reputation platform that would use technology to collect and analyze this data and share it with the central EU database. So on the next slide, I'll talk about each of these in more detail. So the first model is the automated facilitated negotiation model, and that probably would take place during this 8-week waiting period that happens before the parties actually access the ombudsman. And that 8-week waiting period is mandated by law in most places. So in this case, the way we see it happening is probably 4 weeks would be allocated to direct negotiations, and if that doesn't result in any outcome, 4 weeks would be handled via technology. And the technology hopefully would help disputants identify their key interests and find a common ground in the sense that they have not been able to do so in the direct negotiation. There are ways.
Do you think 8 weeks is necessary, or are you just using 8 weeks because that's what's currently required?
So we're using 8 weeks because it's currently required, but that's widely accepted by ombudsmen and other ADR providers, so we don't see that period being changed realistically. And actually, I haven't honestly thought that much about whether a shorter period or a longer period is optimal, but I do know that it's very kind of strongly ingrained in the current culture of the ombudsman and ADR landscape in Europe.
Can I just jump in here quickly, just to respond to that, Professor Rogers? I mean, if there was a single thing that all stakeholders across the various groups we spoke with agreed on was about that 30-day period as contemplated by the EU regulation, that was extremely tight. That may not be realistic, and I personally wouldn't be surprised to see if the lobbying effort involved here would resulted in a longer term. But that 8-week period is something that is built into the system right now. We don't. I mean, you could certainly cut that in half easily. According to our process. I mean, you could probably cut it in in quarters. So it's not. It's really a function of we saw that there was in the existing system there was a huge kind of opportunity space in this 8-week unstructured process that we think we could do a lot more with. But the time there is really a relic of the old process. And what's realistic for the future is probably going to be the result of a negotiation between kind of the national governments and the EU on that 30-day window.
Was that 30-day window like disputes or cross-border e-commerce?
So that 30-day window is included in the ODR, in the proposed ODR regulation, meaning that if you're a consumer with a cross-border e-commerce dispute and you complain to the centralized EU platform, that's day one, your complaint. And then within 30 days, you should have the complaint resolved with your, non-domestic e-commerce vendor.
Okay. And one other question. You keep referring to the stakeholders you interviewed. What percentage were vendors or e-commerce intermediaries versus consumer protection authorities and ADR providers?
So I'd say, basically, when we talk about vendors and that, I'd say it's more kind of industry associations that we were able to speak with. We spoke to to speak to actual actual vendors. No, right? So we used proxies of these industry associations, with the consumer protection organizations and the ADR providers. So in terms of percentages, I'd say about a third were these kind of business interests in terms of our interviews.
Okay. All right, thank you.
Yes, just to reinforce what Daniel was saying, the 8-week period is very widely accepted right now in Europe, and kind of the 30-day time frame that the ODR regulation currently proposes is very strongly opposed. So just going based on that, we're trying to create something that, stakeholders would be amenable to. So that's why we envision this facilitated negotiation going in the 8-week. And we actually see a lot of the disputes that currently go onto the Ombudsman being resolved through this automated facilitated negotiation process, which can really just help people see where the middle ground is, where right now there are communication barriers, language barriers, and so forth. But if that doesn't work, we move on to the actual Ombudsman process, and we think that right now one of the problems of that process is that parties don't really know what the likely outcome is because the process is so opaque in many cases. And so we're going to create this predictive evaluation tool that would take place in the beginning of the process once evidence is submitted. And that tool would gather the evidence, analyze it, and spit out likely results based on past results for that Ombudsman provider. And that result would kind of shape parties' expectations and possibly lead the path toward a settlement happening quicker rather than later. Finally, if none of that works, of course, the dispute goes to the Ombudsman. After that, in the current system, there's no sort of information sharing. No one knows what happens to most of these disputes. There's no stats that are shared. We propose that a technology-based system gather all these stats from the Ombudsman, gather stats on outcomes, on payments, on satisfaction of disputants, and on the kind of information that was exchanged, and that those stats be shared with the EU platform to get these sort of information-based synergies that will get more vendors and consumers to buy into the process. And I talk about that on the next slide. So this is how we envision the information sharing platform is working. So information is gathered from 3 different sources. It's gathered from ODR providers, it's gathered from e-vendors, and gathered from consumers. So ODR providers talk about which industries participate in their purview, which vendors participate in the Ombudsman umbrella, which types of disputes they look at, and how many outcomes tend to be successful. E-vendors would report on how much the process costs to them and how happy they are with the process and whether they're going to stick with it in the long run. And consumers would respond to surveys asking if they're satisfied with the process and asking, perhaps most importantly, whether the process makes them more likely to want to come back to that business and shop with that vendor again. So that data is gathered. It's funneled into this EU platform and distributed back to these 3 key stakeholder groups. ODR providers get feedback from both consumers and businesses on how to improve the actual Ombudsman process. E-vendors get data about the likelihood of return business from consumers, and about the cost of the process compared to litigation. So we think this is huge. We think that if e-vendors know that a successful and efficient ODR process makes consumers more likely to come back to that e-vendor, e-vendors are much more likely to actually join the ombudsman model and to comply with it.
You have here
the
question. You have the cost comparison to litigation. I know at the UNCITRAL working group, there's a fundamental belief that if we don't set up an ODR system, consumers really don't have recourse back to the courts. And here you're suggesting by writing cost comparison to litigation that litigation could actually be an alternative. So was that an assumption that you made right at the outset, that if the consumers can't go to use, if the consumers don't have ODR, they still have the courts, and that's really a realistic option?
So I think that actually touches on a key difference between, I guess, different stakeholders, possibly in UNCITRAL. The way they see it in Europe is that consumers do still have access to the courts, even without ODR. So, and the reason that's true is that even in low-value claims, consumers are able to sue the vendor because Europe uses a loser-pays system, and also many countries have things like legal insurance. So, for example, if I buy something for 300 euro from you, and I feel like I'm not happy with the outcome or not happy with the purchase, and I feel like I'm pretty likely to win my case. First of all, it's covered by insurance, and then if I win the case, you pay for everything as a vendor. So I'm actually losing very much as a consumer. So consumers do have more of an impetus to go to court in Europe than they do, for example, in the U.S. But it is true that consumers with small value disputes often not go to court. Nonetheless, some of these disputes end up in court, and we've seen different analyses that show that the businesses will use these services as long as they're cheaper than litigation overall. So I hope that clarifies it.
Yeah, I mean, just to add to that, we have a slide 49, which kind of shows a little bit on the German point of view, kind of how this is a fundamental difference from kind of what we typically think of in the United States. So I think Eugene's basically captured it. Certainly, so one slide behind us. Yeah, so people are not going to court for very, very small dollar amount or euro amount kind of, disputes. I think the key thing to kind of take away from this presentation as American viewers here is that the threshold is much lower in Europe than it is in the United States, both for cost reasons, which you kind of see on the left side, the loser pays, the proportional legal fees, the legal insurance, but also kind of from a cultural point of view, whether or not the actual consumer is going to go through the hassle of going to court. They may think it's less of a hassle, kind of from a personal point of view, but whether or not they think it's a hassle from a cultural point of view, this is an area of kind of widespread agreement among the stakeholders that we did speak with, was that the option is just an important thing to say we could go there if we wanted to. So even though, the argument is, listen, it's an option to go somewhere where you're never going to go is not much of an option at all. I think that the point we're trying to make here is, or that we've found, is that the option has inherent value just in being an option, whether or not it's practicable, and secondly, it's much more practicable than it might be in the United States in terms of just kind of the access. So.
Okay. And is this is this for domestic cases as well as cross-border, or are these sort of assumptions really applied only to domestic cases?
Dana, I've had to speak to your spot in Germany, but I mean, I guess it's probably true that there is a difference between, for example, a consumer in Germany suing someone else in Germany and someone in Spain suing a vendor in Germany. But I think ultimately many of the recourses are the same for consumers. And someone in Spain has the right to sue someone in Germany under EU law, I believe. And
if they speak German and they're familiar with the court system in Germany and have the resources to file an action in Germany.
Yeah, and
so I could understand maybe the number of cases, smaller cases within Germany is growing, but is that really true cross-border?
I think it's a fair point. It's a good point. I think we're basically projecting the domestic experience onto the cross-border experience in large part because the stakeholders that we're speaking with are doing the same. And the fundamental expectation in the EU is that whatever the ODR solution is, it's going to be built on top of the existing ADR infrastructure. So basically that projection is, we're mirroring those who we studied in terms of making that projection. But I think you're making an important point here, is that there is a kind of fundamental difference between cross-border and domestic disputes. So we're not disagreeing with you.
Probably some of the conclusions you've reached, I know some states are not going to agree with at UNCITRAL, and they're probably going to very much stress the difference between domestic and cross-border cases and say, okay, we might agree with your presentation with regard to domestic cases, but we're in a different world cross-border. And therefore, some of the conclusions you've reached shouldn't be applicable in the cross-border context. I don't agree with that. I'm not saying that so you're aware of it when you go into the UNCITRAL meeting.
I do know that, for example, in England, some of the ombudsman schemes there that are actually, for example, the financial ombudsman there handles just about any claim related to financial transactions for things that occur in England. But actually, people, and that's a scheme that's mandated by law. It's statutory. It's very formal, but it's also purely English. And at the same time, they do allow access to foreigners. And they have some volume of cases. It doesn't seem very large, but they do have foreigners lodging complaints with them. So that's not a court system, but it is an example of how kind of formal adjudication can still work cross-border in some regards.
Okay.
And these kind of loser pays, kind of proportional legal fees, those kind of systems are true in multiple EU countries. So the kind of influence on behavior, it's maybe not exactly the same in the cross-border context, but we're not talking about a situation where it's loser pays in Germany but not loser pays in Spain. So if loser pays is in fact a major driver of access to the courts, then that should be true in a cross-border context as well. But it's very good intel that you're giving us here, Professor. I mean, this is certainly something we'll want to, have in our heads when we walk into the meeting at UNCITRAL. So thanks for that.
Yeah.
No problem.
So if we could just go back to the slide I was on earlier, Daniel, or Colin.
Sure.
There we go. So, again, I was talking about e-vendors and the data they get from the platform. One would be cost compared to litigation, and that would be both domestic litigation and, again, we're not sure of the volume of cross-border litigation, but if there is any, ODR will probably reduce those costs, hopefully, if it's efficient. So sharing that data should drive more vendors into the system, both domestically and cross-border. And finally, consumers would get from the system a list of which vendors in a given industry are participating in this ombudsman umbrella. And so that should induce kind of a race to the top. So if you're buying chocolate in France, for example, and you see a list of providers that are selling chocolate in France, and only some of those are covered by the French chocolate ombudsman, you would want to buy from those providers, presumably. So the ones who aren't members of the team would eventually also want to join it. later on to gain trust from the consumers. Finally, Daniel talked about...
Colin, does that jive with your PayPal experience? Some of the assumptions that are being made? That if you give this kind of information or if you have that trust mark, people are more inclined to buy from that site as opposed to others?
Yeah, I mean, I've been very clear with these guys about my skepticism about trust marks. So, but I think the PayPal experience and eBay experience is slightly different than the broader internet perspective. I'm opening my mind both to the ombuds model and to some of these feedback recommendations. I do think that feedback and reputation is important, but I'm a skeptic on trust marks because I just feel like you get too many trust marks and then they don't mean anything. But I think in the European context it may be different, and I know in Germany, for instance, people take trust marks very seriously. And in the UK, they've had more success with trust marks than we have in the US. I think people in the United States pretty much tuned out all the major trust marks, DVD and VeriSign and Trustee. I mean, they appear on websites, but I just don't think consumers pay any attention to them. But that's not to say that if there was a meaningful resolution trust mark, that it couldn't get traction. So, I'm still not 100% convinced, but I was more of a skeptic than I am now after seeing the results of the research.
Just to be clear, what we're talking about up top is not really a trust mark system. It's more of a central database that categorizes which vendors are actually members to various ombudsman schemes. So when the EU says that, Colin Rule's Chocolate is a member to this ombudsman provider, it's not a trust mark. It's actually the EU saying that. So I think that has a lot more credibility with consumers than just any random trust mark saying that would. But when you do talk about trust marks, we have that at the bottom. Trust marks is sort of the private way of doing the same thing as that EU database would do. And the concerns you just mentioned, Colin, are exactly right. So we don't know right now which trust marks are worthy and which ones are just sort of out there as consumers. So what the EU is trying to push right now, and they're very serious about this, they're proposing a trust mark regulation that would set minimum standards for trust marks that would ensure that each trust mark that's out there actually has sort of real power of enforcement. The consumers actually have reason to trust it. So our recommendation for that trust mark directive is to require each trust mark to make vendors that are parts to it join an ODR scheme that would facilitate dispute resolution in that specific industry. So we think that would go a long way towards replicating the same sort of thing inside of trust marks as we would have in a central, largely public, actually, EU platform that would share data across the European e-commerce market. And on that note, that's kind of the bulk of our findings, so we'll take any more questions anyone has.
Sure. The last thing that I'll put in there on the trust mark conversation, because I know we've talked about this to death, so you don't need to hear more from me, Eugene, about it, but I think there are a lot of complexities. You don't see a lot of public trust marks out there. The U.S. government does not run a lot of trust mark schemes, and EU doesn't run a lot of trust mark schemes. They often create private entities or they have nonprofits that do it, because it's tricky. It's easy to do up front to say, okay, well, the good guys are going to get the seals and bad guys don't get the seals. But once you get into the ugly business of actually administering a system like this, it's very hard for public entities to do that because they don't want to alienate their constituents, and they have too many masters. So, I think there definitely is going. Let me make this unqualified statement. Trust marks and reputation is going to be a big part of any successful platform, regardless of whether or not we're talking about the EU ODR scheme or the UNSTRAL ODR scheme. But I think there's still a lot of TBD on it.
I absolutely agree with that. I just want to come back to that once again, though. The one thing I would say about the public issue is that we're not asking for example, the EU to actually evaluate which vendor is good, which vendor is bad, which ODR provider is good, which ODR provider is bad. All they're doing is just saying, these guys are part of it, these guys are not. So it's a very binary kind of data they're actually analyzing. It's not, there's no qualitative measures there that require discussion of any sort. So we're trying to limit their sort of the way we're trying to make sure that public entities don't really compromise their standing in the eyes of the public by doing this.
Absolutely. Absolutely. All right, well, I know we're over time here, and I've got the recording, so now it's great, because now I can send the recording out to a bunch of other people. So, Vicki, do you have any last questions? I know you're going to get more opportunities to provide in-depth feedback, but I appreciate your questions during this presentation.
Can I just ask one last one?
Sure.
Which is a general one, which is, what do you see the relationship is between the UNCITRAL framework as it currently exists and future EU ODR developments?
So we actually have a slide on that, and this slide 21. There it is. So obviously, I guess the biggest difference between the two, between the EU point of view and the UNCITRAL point of view, as we understand it, is the emphasis on binding processes. And from our findings, the EU is just not very amenable to having a process that's binding. So with that in mind, we're looking to identify other interests in which the EU and UNCITRAL would find common ground, and we think that some of those would include kind of building on these key characteristics at the top. So availability and transparency, everyone thinks those are important. Reliability of providers and efficiency, building toward those goals would be kind of the main aim of a joint effort there. So constructing this global clearinghouse that would share information about ODR processes around the globe, not just Europe, would be something that both kinds of stakeholders agree on. Setting minimum standards for technology and neutrals and platforms is another thing. Reputation we talked about just now. That's another area where there's a lot of room for building consensus. And finally, facilitating access to technology. A lot of countries right now just don't have anyone providing ODR. So if UNCITRAL pushes kind of these new state-of-the-art processes and promotes them in areas of the world where they don't exist, that's a major value add for many parts of the world and Europe as well. And that's something that the EU would be absolutely on board with and very much coheres with the EU's current vision of how this works.
So you think the EU is going to ignore the UNCITRAL rules and the framework, set up their own?
I think that if there's a message that we could kind of send here from our research and how it relates to the UNCITRAL draft rules, I think there's kind of three levels of enforcement or enforceability here that are kind of in play. There's the first pre-dispute binding requirement in the HNCMP style. From our findings, that is universally kind of rejected among the stakeholders that we spoke to. I literally do not speak to one person who thought that would either not only kind of be within the rules, but was even feasible in terms of setting up a European system. That's not even part of the conversation right now, whether or not to have this style, kind of AT&T style, pre-dispute binding. Then there's the kind of middle ground of an opt-in. Once there is a dispute, whether or not the parties can opt into a binding process. That is at least possible. The EU proposed regulation does kind of contemplate that by saying that the platform will inform the consumer and the trader as to whether or not the process that they're entering into is binding. And then the third thing is just kind of what we're talking about as kind of reputational feedback, information feedback that creates an incentive to participate, but is stopped short of any sort of requirement. So basically, our recommendation is formed around this kind of reputational feedback, creating incentives for participation, because we think that's kind of the most likely outcome in Europe, and we think that to the extent that the UNCITRAL crowd wants to influence what's happening in Europe, we think building up these reputational feedback systems, kind of providing additional information about who the providers are, what ODR means, how ODR works, who are technology providers that can provide ODR. That kind of information sharing can be, a robust grounds for collaboration. If the UNCITRAL crowd is kind of wholly dedicated to kind of binding processes, they'll have to be ones that allow both parties to opt in. All of the papers that we read, or many of the papers that we read, and the people that we spoke to, kind of describe ADR as an inherently voluntary process. This kind of principle of voluntariness is at the heart of how people think of what ADR is in Europe. And so any kind of ODR system, which in the Europeans' minds is going to sit on top of the existing ADR infrastructure, anything that's going to be called ODR in Europe is going to have to maintain that kind of voluntariness, which is so central to what the understanding is. So the only way to kind of fudge it is at least to have that kind of middle ground opt-in option.
When you say opt-in, are you meaning opt-in post-dispute then? Because pre-dispute arbitration agreement is still voluntary. Theoretically,
I realize that that's true. Right. Kind of the feeling in Europe is the kind of American style contracts of adhesion are not, while they're voluntary in the sense of, yes, I can volunteer to participate in this process by virtue of making this purchase. There isn't kind of an explicit separate question with regard to the dispute resolution. So when we say voluntary, at least from the perspective of those that we spoke to, that voluntariness has to come after the dispute has already occurred.
I would take it a step further and say that many stakeholders, especially in the UK, emphasize that not only is a pre-dispute binding idea not acceptable to them, but even post-dispute, they're not favorable to opt-in. They want to maintain kind of the conditionally binding ombudsman model where, at best, the vendor is bound, the consumer is never bound, and they think that's a bedrock principle of their justice system. And, one day that may change, but I think we're very, very far from that. So realistically, in terms of finding a compromise, that's not likely to be something they budge on for, quite a while. And beyond that, I think many ombudsman schemes in the UK and other ADR providers are actually building their infrastructure without regard for centralized regulation from either UNCITRAL or the EU, and they're just doing whatever they think is best for their industry. And they're adding technology, they're scaling up, they're broadening their horizons, and they're saying that we are not consulting with these central regulations, these directives. We're just doing whatever it takes to deliver justice to our industry, in our view. So it might be that within a few years, these models are actually built up in a very robust way in England, and at that point, it's going to be too late to change them and shape them according to a certain centralized vision.